Before you answer a single question from a police officer in this country, there are 3 words you need to say first. And by the end of this video, you will have them, plus the 3 short lines that come after them. Because those 4 lines together handle every police encounter you are ever likely to have. At your window, at your door, on the pavement, one system, 4 lines, same order every time. And I want to be straight with you about why it matters. Most people who get themselves into trouble are not undone by something a detective dug up. They are undone by sentences they gave away for free in the first 5 minutes to somebody who sounded friendly. It is almost never criminals this happens to. It is polite people who thought cooperation meant conversation. But there is something else, and it is the reason I am making this, rather than simply repeating what you have already seen. A great many of you have learned these 4 lines from American videos, and one of the 4 does not work here. Said the American way, in England or Wales, it is the line most likely to be used against you in court, so we are going to fix that one properly. My name is Oliver Bennett, and for 15 years, I stood in police stations and courtrooms across England and Wales on the wrong end of a great many conversations that went badly for somebody who had done nothing much at all. Everything tonight is England and Wales. Scotland has its own system, and I'm not going to pretend otherwise. And every line I quote tonight comes off the legislation or the pace codes of practice. I will put the words on screen so you can read them yourself rather than taking my word for it. Line 1, am I being detained or am I free to leave? Those are your 3 words in the English version. Not aggressive, not clever, just a question that forces the encounter to show you what it actually is. Because until you ask, it can be either, and the officer has no obligation to volunteer, which every encounter with a police officer is one of 2 things. Either you are free to go, in which case the rules of the conversation are yours, or you are being held, in which case there has to be a power holding you, and it changes what you should say. The whole point of the question is that it cannot be both. And here is why the question works. Police and Criminal Evidence Act, Code A, paragraph 2.11. There is no power to stop or detain a person in order to find grounds for a search. Read that again because it is doing an enormous amount of work. They cannot hold you in order to find the grounds. The grounds have to exist first, which means a stop that begins as a fishing expedition has nothing underneath it. And the question exposes that in about 4 seconds. And the same code, paragraph 2.1010. In the absence of any other lawful power to detain, the person is free to leave at will, and must be so informed. Must be so informed. It is not a favour you are asking for, and it is not cheek. The code puts the obligation on them. You are simply inviting them to do the thing they are already required to do, and that is why the question almost never causes a row. Line 2, and this is the one the American videos get wrong for a British audience, so I want you to listen carefully because getting this backwards is genuinely expensive. In the United States, silence is free. You say you are invoking your right to remain silent, and that is the end of it, and nobody may hold the silence itself against you. It is a clean rule, and it is why their script says what it says. Here it is not. And you already know the sentence that tells you so because you have heard it on television 1,000 times without once hearing what it actually says. Here is the caution itself word for word, and it is worth reading rather than half hearing. You do not have to say anything, but it may harm your defence if you do not mention when questioned something you later rely on in court. That middle sentence is the entire difference between the 2 countries, and it is a warning rather than a formality. It is Section 34 of the Criminal Justice and Public Order Act, 1994, and it means a court can be invited to draw a conclusion from what you left out. But, and this is the part that rescues the whole thing, that power bites only on questioning under caution. A friendly, "Where are you off to tonight?" on a pavement is not that. Nobody has cautioned you, so nothing you decline to say, there can be held back against you later. So line 2 is not the American sentence. Do not stand at the roadside announcing that you are exercising your right to silence because you have imported a protection that does not exist here in that shape, and you have made an ordinary conversation look like a fight. Line 2 is this: I would rather not answer questions. That is all. It is not a legal formula. It does not need to be. And it says the same thing without dressing it up in somebody else's constitution. And if you are ever actually cautioned, if you